Yes, thank you for the opportunity, and I'll give you a grounded analysis embedded in substantive legal provisions. The core question it revolves around whether an accused person can unilaterally hold criminal proceedings. The definitive starting point is Article 28 sub Article 5 of the 1995 Uganda Constitution, which provides the fundamental rule that a trial shall not take place in the accused's absence without their consent. However, it immediately carves out a critical exception. The trial can actually proceed in absentia without consent if the accused's own conduct renders their physical presence impracticable, and the court makes a formal order for their removal or for the trial to continue. So the Criminal Procedure Code reinforces this default in terms of the rule of presence at trial and provides a mechanism for compelling attendance, but it does not create a general power to bypass the constitutional threshold. And that is extremely important in the context of the discussion of Dr. Kiza Besigye. Now, you asked wonderful questions in the context that, for example, can an inmate refuse trial? And was the president honest in his deliberation on this matter? Now, legally, an inmate cannot actually deliver an absolute veto to permanently stop a trial. So, the right to be present is actually a personal right that can be forfeited by conduct. But under Article 28 sub Article 5, a trial in absence without consent is strictly conditional. It is not only permissible where the court finds that the accused's conduct, for example, persistent disruption or even sustained refusal to attend after due warnings, it makes the continuation in their presence impracticable, and the court therefore issues an explicit order to proceed without them. Now, obviously, the CPC backs this by permitting warrants and even in certain appellant contexts, hearing matters in the appellant absence for what they call warrant of prosecution, though these are secondary to the constitutional mandate in that context. Now, on the president's honesty, for example, we could argue that if the public statement meant that the law provides a narrow, perhaps, or judicially supervised pathway to proceed despite a boycott, it is legally accurate and grounded in Article 28 sub Article 5 and in terms of the PCC, in terms of the procedures. However, this statement is actually implied that Besigye's refusal is irrelevant and the state can actually immediately hold an absentia trial without a judicial finding of impracticability, and that would overstep the law. So the constitutional safeguard is a formality. It's not a formality, but it is a substantive limit that requires reasoned court order in the context of the discussion in as far as the president tried to make that allusion. Now, number two, in the context whether or not if Besigye says no to state lawyers, can the case actually proceed? Now, I would argue this in the context of the following. I would argue and say yes, the case can actually proceed. Why? Because the right to counsel is a waivable right, not a mandatory obligation. So when you look at Article 28 sub Article 3 of the Constitution, it guarantees an accused person the right to appear in person and to be present by a lawyer of their court choice at their own expense. So crucially, the offenses carrying death or life imprisonment like treason, the state is constitutionally obligated to offer legal representation at the state's expense if the accused can actually not afford one in that context. Okay. Now, however, in the Ugandan jurisprudence, it firmly establishes that this is an offer, not an imposition. So if Besigye, after being properly and adequately advised by the court of his rights, explicitly refuses, for example, the state-funded lawyers, and either elects a self-representation or retains private counsel, his refusal does not constitute a procedural bar. So the trial can lawfully continue with his private counsel or with him representing himself, provided the waiver is knowingly, intelligent, and voluntary. So a mere rejection of the state alternate does not trigger an indefinite stay of the proceedings. That is also extremely important to understand. Now, the other question in the context of whether or not they can actually find a gap in the law to try Besigye without his consent, I would argue as a constitutionalist in the context of constitutional jurisprudence that there is no statutory loophole that actually nullifies the clear text of Article 28 sub Article 5. So, however, there is a strict constitutionally embedded pathway that allows a trial to proceed without consent, based entirely on the accused's own conduct. So this is not a gap, but it's a built-in exception within the Constitution itself. So for this exception to be triggered, for example, we have to look at two cumulative judicial conditions that actually must be met. Now, the first one is that the court must make a specific finding that Besigye's conduct, for example, his political boycott or even refusal to recognize the court's jurisdiction, has actually rendered the continuation of the proceedings in his presence impracticable. And this is a high threshold that typically requires warnings and even exhaustion of alternatives, like production warrant, for example. Yes? Now, number two, we could also argue that the court must actually issue what they call a formal order for his removal and direct the trial to proceed in his absence. Yes? So the point here, my friend, is that a mere political boycott is not automatically impracticable. The court would actually need to demonstrate that his actions actively sabotage the ordinary conduct of the trial. So if the court makes that reasoned finding and issues the required order, then the law, the CPC, allows the trial to continue via warrants and even normal absence procedures, making any manufactured gap in courts unnecessary. So this is extremely important in the context of constitutional jurisprudence as far as this is concerned. Now, in terms of a dispensation, if you like, in terms of the overlay of international law, if you look at the ICCPR and the fair hearing standards, we have to quick to note that Uganda is a state party to the International Covenant on Civil and Political Rights, what they call the ICCPR, and its standards form part of the interpretive framework for fair hearings. So when you look at Article 14, for example, of the ICCPR, it guarantees the right to be present at trial in terms of international jurisprudence from the UN Human Rights Committee. They accept trials in absentia only under strict narrow conditions. The accused must have been duly notified and their absence must constitute a clear voluntary waiver or deliberate avoidance of the process. So those are fundamentals and must be obliged with in the context of international jurisprudence. Therefore, even if the domestic exception under Article 28 sub Article 5 is actually triggered, a procedurally defective in absentia trial that fails to meet the ICCPR's due notice and waiver standards risks international legal inconsistency and reputational damage, and would actually be vulnerable on appeal or even before regional human rights fora in that context. So that's extremely, again, important in the context of international jurisprudence in light of this issue that is the nation is facing. So in light of what I would argue for purposes of this discussion, the final grounded assessment in terms of the synthesis that we are having, the constitutional synthesis, it would be in the context that, number one, Besigye, or Dr. Besigye for that fact, cannot lawfully stop the trial forever by refusing to attend or even rejecting state counsel. The trial process remains its momentum under Article 28 of Article 5 and under the CPC in terms of the mechanism that are provided for. So the state obviously cannot simply ignore his rights. It must meticulously satisfy the aspect of the impracticability and the court order requirements under Article 28 of Article 5 and the fair hearing standard in terms of that. So the refusal of state lawyers is not a fatality in terms of the prosecution. The trial can actually proceed with private counsel, even self-representation, provided the waiver is informed and the voluntary aspect is covered under Article 28 of Article 3. The state overrules and also the waiver jurisprudence in that narrative. So any attempt to manufacture in terms of the gap, treating a boycott as an automatic waiver without proper judicial finding would actually be legally fragile and therefore violation of Article 28 of Article 5 and the vulnerability in terms of the CPC as a challenge and also subject to international condemnation under the ICC PR standards. So that has to be married together to have a symphony of criminal procedure, constitutional criminal procedure that actually would be wanting in light of the case of Dr. Kizza Besigye. So I thank you and I hope that addresses the questions that we have today.